Welcome to What Does the Law Say with Irike. Today we'll be discussing about adoption in Nigeria. But before we move on, if you have not subscribed, click on the subscribe button and don't forget to share. So, adoption in Nigeria. There are different and various reasons why people have to adopt a child in Nigeria. Maybe due to health reasons or, financial reasons or other reasons or, to help somebody, to help a child. That's why people have to adopt in Nigeria. But to begin today, we will examine the provisions of the Child Rights Act 2003 to understand the steps and all that needs to be done when it comes to the adoption of a child in Nigeria. So what are the first steps, or what are the steps that you have to ensure you have to take before a child is being adopted or before you can adopt a child? The first thing is that you have to make an application. You make an application to the court for adoption. And now when you make the application to the court, there are requirements that you must fulfill. In the case where you're a married couple, your marriage certificate or a sworn declaration of marriage would be needed. Your passport photograph, a medical certificate, to ascertain the fitness of the applicant, from a government hospital, and many other requirements as deemed by the court. After you make the application for adoption to the court, the next step is investigation. So who will investigate? The court does. The court is the one that would go ahead to do an investigation on this applicant. They want to be sure, they want to ascertain that you're a credible person. They want to be sure that you're not going to cause any harm to the child or, be of any negative, impact to the child and things like that. So the court decides to investigate that person, either through a child development officer or a supervision officer. And the main reason for investigation is to be able to protect that child, to safeguard the child. Remember that under the Child Rights Act of Nigeria 2003 and also the International Convention on the Rights of the Child, the best interest of the child is always the primary consideration. So throughout the life of a child, you want to look out for the best interest of that child. That's the primary consideration. So in investigating, we need to make sure that we look out for the welfare of this child. We need to make sure that we can ascertain the wishes and the feelings of the child regarding the decision. We want to make sure that it's safe for the child. After investigation, the court reaches a decision, and that's the next step. So after investigation, the court reaches a decision whether to go ahead with the application or not to go ahead with the application based on the investigation. So the next thing we'll talk about now, that who may be adopted. Section 128 of the Child Rights Act of 2003 provides for persons who may be adopted, and it states that in the event that there's a parent, or if there isn't a surviving parent, a guardian that consents to the adoption of that child, such a person may be adopted. So if a child or a person doesn't have consent either from his parent or a guardian, that child cannot be adopted. The second instance when a child or a person may be adopted is when the child has been abandoned or has been persistently abused or ill-treated or neglected, or there are reasons, clear reasons as to why that child needs to be adopted. Then that person would be adopted. So now, who are the persons that may adopt? Section 129 of the Child Rights Act of 2003 provides for persons who may adopt, and it states that the following persons may apply for an adoption order. So a married couple, where each of them has attained the age of 25 years and there's an order authorizing them to jointly adopt a child. So if you're above the age of 25 years and you are married and both of you jointly agree, consent to the adoption of a child, then you can adopt a child. Also, a married person, if he has obtained the consent of his spouse, can also adopt a child. So maybe in the event that you're not jointly adopting the child, but you've gotten consent from your spouse, as a married couple, you can, or as a married person rather, you can also adopt a child. Thirdly, a single person, I'm single, so I can adopt a child. A single person who has attained the age of 35 years, provided that the child that is to be adopted is of the same sex as the person adopting. So if you are not single, you can adopt at 25. That means if you are married, you can adopt at the age of 25 years. But if you are single, you can only adopt at the age of 35 years, and you must adopt a child that is of the same sex. In all cases I mentioned now, in all the cases of persons who may adopt, the law also states that the adopter or adopters shall be persons found to be suitable to adopt the child in question by the appropriate investigating officer. So if I were to be married, for instance, now, and I want to adopt a child, and I'm 25 years of age, I can adopt that child as long as after investigation, the investigating officer finds me suitable to adopt that child. Then I can adopt the child. Now, after we've looked at the persons who may adopt and persons who may be adopted, the next thing that goes on after that is the adoption order. So, application, investigation, decision, ascertain the suitability of the adopter. Then the court would grant an adoption order for that person to be adopted by the adopter. Moving on, the effects of adoption. So the court has granted the adoption order. The child has, or the person, a person has become your child. There's no illegitimate child. So as long as you've adopted the child has become your legitimate child. It has become your own, like as if you gave birth to the child. So what are the effects of this adoption? What has changed? What has happened? What is the effect of that adoption order? Section 141 of the Child Rights Act provides that all rights, all duties, all the obligations, anything personal that was applicable to the parents of the child or the guardian of the child, whether it has to do with the maintenance, supervision, education, welfare, including religious rights, the right to appoint a guardian and whatever, has been extinguished. That means the parent or the guardian of the child before adoption no longer has all these rights, no longer has all these duties, all these obligations, no longer have these liabilities, no longer are responsible for the child's education, welfare, maintenance, or anything like that. All those rights, all those liabilities, all those obligations have been extinguished. So now, who has the right? Who has the obligation? In whose hand is the liability and the duty to take care of this child? So that same section 141, subsection B, says that they shall now vest in and be exercisable and be enforceable. So the adopter now has all that right. The adopter now has all that obligation, all that duty in respect of the future custody, maintenance, supervision, education of the child. So as long as an adoption order has been given, as long as all the processes have gone through, that adopter now has future custody, has all the rights, all the obligations, all the liabilities to take care of the child. As much as the effects of adoption, cuts across all the rights, duties, the obligation, the liabilities, that have moved from the parents of the child or from the guardian of the child to the adopter. So everything, it encompasses everything. Subsection 3 of this section says that for the purposes of the devolution of property on the intestacy of the adopter, an adopted child shall be treated as a child born to the adopter. So now, in the event that the adopter dies, writes a will, nobody can say that the adopted child is not a legitimate child, is an illegitimate child, or was not given birth to naturally. No. As long as there's an adoption order, as long as that child has been adopted, it is seen that he is like a natural child to the adopter. Except if there's a contrary thing written or there's a contrary interference. If there isn't that child is seen as a natural child of the adopter. So hey, 25-year-olds that are married, 35-year-olds that are single and are financially capable, you might want to help a child that might have been abused or mistreated or neglected, or you might want to just help a parent or help a guardian, adopt the child and take care of them. If you have that financial capacity and if you are willing, have that large heart, why not? You can adopt a child. So this might not just only be for you. You might say that, well, I'm not going to adopt a child, but you might have a relative somewhere that wants to adopt a child but does not know how to go through the process. So you can just share this video with them and let them learn about the adoption of a child in Nigeria. Thank you very much for watching today's episode of What Does the Law Say with Arike. If you have not subscribed, subscribe and share and like. What does the law say? I'll tell you next Thursday.